Hello everyone, my name is Merisa Sirait, and in this video I will give a brief presentation about forensic linguistics. Forensic linguistics is a branch of applied linguistics that looks at the relationship between language and the law. For example, looking at linguistic aspects of how crimes are investigated or how trials are conducted, including evaluation of written evidence and the language of legislation. Forensic linguistics involves the application of scientific knowledge to language in the context of criminal and civil law. Forensic linguists have an interest in understanding the language of the written law, its complexity and its origin, as well as the use of language in forensic procedures. They also study the judicial process from point of arrest and through the interview, charge, trial, and sentencing stages. For example, linguists are interested in the language of police interviews with witnesses and suspects, and in the language of lawyers and witnesses in cross-examination. The term forensic linguistics was coined in 1968 by linguistics professor Jan Svartvik in his book The Evans Statements, A Case for Forensic Linguistics. Jan used the term in the context of reviewing the statements of Timothy John Evans, a Welsh truck driver who was sentenced to death by a British court on the alleged murder of his 13-month-old baby girl, Geraldine Evans. Main branches of forensic linguistics. First, the language of written legal text. Here, linguists are interested in both the arcane vocabulary, complicated grammar, and infrequent punctuation which typifies many legal texts, and the consequent problems lay readers have with these texts. The second one, the spoken language of the legal process. Here, linguists examine the nature of police interviews with suspects, the specialized rules which govern interaction in courts of law, the problems created for vulnerable witnesses, and the difficulties experienced by those who do not speak the language of the court. Third, the linguist as expert witness. Here, linguists express opinions on the confusability of rival trademarks, on the authorship of documents, on the meaning of words and expressions, and on the place of origin of asylum seekers to the name of few. Fourth, author identification. The identification of whether a given individual said or wrote something relies on analysis of their dialect, or particular patterns of language use, vocabulary, collocations, pronunciations, spelling, grammar. Determining who wrote a particular text by comparing it with the writing sample that known by the suspect, sometimes also called a forensic style of language. Fifth, discourse analysis. Discourse analysis deals with analyzing written, oral, or sign language use, or any significant semiotic event to help determine problems such as those that introduce the topic or whether a suspect agrees to engage in a criminal conspiracy. Sixth, forensic stylistic. This discipline subjects written or spoken materials, or both, to scientific analysis for determination and measurement of content, meaning, speaker identification, or determination of authorship in identifying plagiarism. Seventh, linguistic dialectology. This refers to the study of dialects in a methodological manner based on anthropological information. It is becoming more important to conduct systematic studies of dialects, especially within the English language, determining the language dialect of a person speaking, usually to indicate that the defendant has a dialect different from the one on the aggravating record. Differently from the sound of identification, which analyzes the sound acoustic quality, dialectology uses linguistics feature to accomplish the same goal. 8. Forensic phonetics. The forensic phonetician deals with the production of accurate transcription of what was being said. Transcription can reveal information about the speaker's social and regional background. Forensic phonetics can determine similarities between the speakers of two or more spirit recordings. 9. Forensic transcription. The two main types of transcriptions are written documents and video and audio records. Accurate, reliable text transcription is important because the text is the data which becomes the available evidence. 10th, variation. Intra-author variations are the ways in which one author's texts differ from each other. Inter-author variations are the ways in which different authors' writing varies. Two texts by one author do not necessarily vary less than the text by two different authors. Types of forensic linguistics text. First, emergency calls. In an emergency call, the recipient or emergency operator's ability to extract primarily linguistic information in threatening situations and to come up with the required response in a timely manner is crucial to the successful completion of the call. Emphasis on intonation, voice pitch, and the extent to which there is cooperation in between the caller and the recipient at any one time are also very important in analyzing an emergency call. Full cooperation includes frank and timely response. Second, ransom demands on other threat communications. Threat is a counterpart of a promise and is an important feature in a ransom demand. Ransom demands are also examined to identify between genuine and false threats. Third, suicide letters. Suicide notes generally have sentences alluding to the act of killing oneself or the method of suicide that was undertaken. The contents of a suicide note could be intended to make the addressee suffer or feel guilt. Genuine suicide letters are short, typically less than 300 words in length. Extraneous or irrelevant material is often excluded from the text. Fourth, final death row statements. Final death row statements, also just called final or last statements, are a relatively recent addition to text type in forensic linguistics and stem from the long-standing American tradition of allowing the condemned person to say a few words immediately prior to execution. Death row statements either admit the crime, leaving the witness with an impression of honesty and forthrightness, or deny the crime, leaving the witness with an impression of innocence. They may also denounce witnesses as dishonest, critique law enforcement as corrupt, in an attempt to portray innocence or seek an element of revenge in their last moment. Fifth, confessions and denials by public figure. These are public figures responding to their accusers, sometimes in public and sometimes in private. In this text, diverse as they are, we have prominent people, some of whom are members of the establishment, facing and responding to the establishment. That's all my presentation for this video. I apologize if during my presentation I did some mistakes. Thank you for your attention and thank you for watching.